Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott talks law, and in this episode we are going to talk about bailment under commercial law. So bailment, this refers to the transfer of possession or delivery of goods upon trust from one person to another, from the bailor to the bailee, on particular set of conditions or contract, whether expressed or implied, that the goods shall return to the bailor after the elapse of time, purpose, and the intention and the use of that goods has elapsed. So this is the voluntary transfer of possession or the delivery of goods from the bailor, that one who possesses the title of ownership, to the bailee who possesses the goods temporarily on particular set of conditions or a contract, whether expressed or implied, like whether statutory or just expressed, that these goods shall return to the bailor after the time, use, and the purpose for which it had intended has elapsed. So the bailee has that will use these goods temporarily, will have these goods that so the bailor is the one that possesses that title, ownership title. And an example scenario is where you borrow a laptop to use it for maybe assignments, then you shall return it later after you are through with the assignments. So you as the bailee, you must return the laptop after you have finished with your assignment to the bailor who has lended you the laptop. So that term is the purpose for the bailment or the use. So another example scenario is where you go to a supermarket and you place your luggage at that place where they keep luggage, then you go for shopping. After you are through the shopping, you come back and pick your luggage as the bailor from the bailee. So in effect, the person whose possession of goods are placed must ultimately restore them to the bailor. So the bailee must ultimately restore the goods to the bailor. So let's look at the nature of bailments. So bailment is a unique concept recognized under common law, and is so independent from contracts. It has no relationship with the contract. So it's independent of contractual in that it may or may not arise from a contractual position. So independent. It can arise, it can also not arise from a contractual position. And we have a classical case that establishes this law of bailment, and that one is the case of Cobbs versus Barnard, a 1703 case, LD 909 Raymond. So a classical case is that one that establishes a principle of law. Like on strict liability, you have this case of Raylands versus Fletcher. On negligence, you have the case of Donogh versus Stevenson. These are cases that establishes a particular law. Donogh versus Stevenson establishes a law on negligence, and that one of Raylands versus Fletcher is a case classical that establishes the law on strict liability, the Raylands versus Fletcher. So under bailment, you have these case classicals of Bernard versus Cobbs, and this is the case whereby Bernard was negligent in carrying out his task. So he did it gratuitously by undertaking to transport the barrels of brandy. So these brandies they were destroyed, and he claimed that he just took it gratuitously. He had no intention to do the transportation, he just did it out of gratitude, show gratitude. So Lord Galley found that Miss Bernard, the defendant, was negligent in carrying out the task, and was therefore liable as a bailee. So if you are a bailee, if anything happens to these goods that you are holding, then you are liable under bailment. So the case of Cox versus Barnard came to overturn the then leading case of South Cote versus South Cotes, the 1601. So the South Cotes case was the leading case at that time, but before the before this case of Cogs versus Barnard. So when this case of Cogs versus Barnard came, it overturned this case of South Cortes. So in Brainbridge versus Farmstone, 1838 8 AD, this is the case whereby the defendant had obtained the consent of the plaintiff to weigh two boilers, and the defendant claimed that he was going to weigh this. So the defendant promised to return the boilers in their original state after weighing them. So the defendant had promised to return the boilers in their original state after weighing them, the two boilers. So this defendant did not return the boilers to their own original state. He was sued, and the defendant was claiming that, or he was pleading that he was not paid consideration. So the defendant was claiming that he was not paid consideration, and the quiz bench rejected the plea. Because he was entrusted by the plaintiff to weigh that particular boilers, those boilers. So the consideration is not important here. So the defendant was just liable because he did not return the goods in their own original state. So Lord Denman observed as follows, that the defendant had some reason for wishing to weigh the boilers, and he could do so only by obtaining permission from the plaintiff, which he did obtain by promising to return the goods in their conditions. In other words, there is no requirement to finishing valuable consideration beyond the fact that the entrusting of the goods to the custody of another. So the main important thing here is the entrusting of the goods to another person's custody. This bailee who has that custody in goods is liable if these goods are breached. The consideration there is not important, is of less importance. The fact that the defendant was in possession of goods, or was in custody of goods, and he did not return the goods to the original state, then he is automatically liable according to Lord Denman. So another case is of Building and Civil Engineering Holding Scheme Management Limited versus Post Office 1960, 1QB247. Lord Denning, MR, stated as follows. So Lord Denning is famous because he appears in many cases. So Lord Denning, MR, stated as follows regarding to the nature of bailment. At common law, so according to Lord Denning, just saying that bailing is less associated with the contract. So at common law, this according to Lord Denning, at common law, bailment is often associated with contract, but this is not always the case, as an action against a bailee can often be put not as an action in contract nor tort, but as an action on its own sui generis, independently. Sui generis means independently. Bailment is independent of contract, it's independent of torts. So bailment is an action as its own sui generis, according to Lord Denning, arising out of possession had by the bailee of goods. So it arises from that person who was selling these goods in custody for the bailor. So it's independent of a contract, it's independent of the agreement that were made, it's independent of agreements of consideration. So the agreements whether the parties are intended to pay each other, it's not important, it's of less important here. What's important here is that holding of goods in custody. So according to Lord Denning, at common law, bailment is often associated with contract, but this is not always the case. Of an action against a bailee can often be put as an action in a contract. So cannot be put as an action in contract nor in a tort, but as an action of its own. So that was according to common law that held that bailment is often associated with contract. But according to Lord Denning, nowadays bailment is not associated with contracts. So if you are a bailee and you happen to tamper with the goods of the bailor, you are liable because the terms of the agreement or the contractual agreement is not important here. What's important here is you held the goods in custody and you tampered with them, then you are automatically liable. So the creation of bailment, let's look at how the bailment is created. So So there's no formal requirements for the creation of bailment at common law, as long as the particular agreement made the basic function by which it is defined. Property remains with the bailor. Possession lies at the heart of the bailment. So the property remains with the bailor. The bailor has this ownership title. He owns this property and he just transfers temporarily the goods to the bailee. So the case of Ashby versus Toll has 1937 KB 242. A car parked and the car. So this case of Ashby versus Toll has, this person parked the car and went to do some transactions. So he went to the keys and left the car at the parking place. So when he came back, he found the car had been tampered with. So the people there were claiming that they were not liable because they were not given the car keys, they were not given that responsibility to take care of the car. So they were claiming that they were not liable. So the bailer retains a superior interest in the chattel, that of so the bailor has that superior title because he's the one that owns the property. So the bailee must consent to take possession of the chattel for there to be bailment. So if the bailee does not consent or agree to take that particular chattel, then there's no bailment. The bailment must only occurs when these two parties have agreed, when the bailee has agreed to take that particular chattel. But when the bailee does not agree to take that particular chattel, then there is no bailment. So let's look at the types of bailment. We have indefinite terms versus fixed terms, and we also have gratuitous bailment versus bailment for consideration. Gratuitous bailment is that one for free, and bailment for consideration is that one which is paid for. And we also have voluntary and involuntary bailment. So indefinite terms versus fixed terms. Section 14, Section 4 states that disposal of uncertain goods act by. So the disposal of uncollected goods according to Act Cap 38. So if these goods are not collected, the bailee has that right to dispose them according to Section 4. And Section 5, notice to take delivery needs to be given at least 30 days. So the bailee must give notice to the bailor at least for 30 days for the bailor to come and take that goods. If you are holding this particular bag for the bailor, you must give him a notice of 30 days. If this is a laptop, give him a notice of 30 days to come and take or repossess his laptop. And Section 6, if he does not, according to Section 6, notice of intention to sell should be given before the goods are sold. The notice should be for a period at least 90 days. So if the bailor does not take these goods, you must give him a notice for sale. You have not taken your goods. I'm selling these goods, and this is a notice for sale. You must give him a notice for sale, and this notice for sale must last for at least 90 days. So why should this bailee sell? Because when these goods are in possession of a bailee, the bailee is incurring some losses and some expenses. So he's spending on those particular goods, and he's allowed to sell that goods to compensate for what he had lost. So Section 7, if the notice are not honored, the bailee may sell at the best price possible to offset the expenses and pay the bailee or claim the bailee the balance. So he pays the balance to the bailee after he has repaid for what he had the expenses that he had incurred. So another one is the gratuitous bailment versus bailment for consideration. And gratuitous bailment is that one paid for a fee, and bailment for consideration is whereby for free. Gratuitous is for free, just show gratitude. The bailee keeps the property for the goods from gratuitous point, just to show gratitude. But the bailment for consideration is where you keep them for pay. You're keeping these goods as a bailee for the bailor for a particular amount of payment. So the person holding the chattels be paid for the action. And so voluntary versus involuntary bailment. is also another category. So you have 6 types of bailment, but we've just looked at 3 of them. So bailment and third party. The bailee possesses him and so this bailment and third party, this arises where there is a vicarious liability. So the bailee possesses and gives him sufficient legal interest and the goods to be able to resolve them against loss or damage and risk. So if you are the bailee and these goods are damaged by the third party, you as a bailee, you are liable under vicarious liability. So duties and liabilities of the bailee. So we are now looking at the duties of both parties, both the bailee and the bailor. So the bailee, that person who holds these goods in custody, what are his duties? So the bailee has the duty to take reasonable care of the goods. You must take the reasonable care of the goods as a bailee. So this care is central between the relationship between the bailor and the bailee. It depends on the relationship that you have, both of you. The onus of the bailee is to prove that he took appropriate degree of care under the circumstances. So you as a bailee, you have that onus to prove before the court if you assume that you took reasonable care of that goods that you are given. So the bailee owes a duty not to neglect, as he will be liable for negligence. So if you neglect, you don't perform your duty of care as the bailee, you breach your duty of care, which leads to damages. So you have this duty of care, you must keep them according to what you had agreed. So if you don't, you are therefore liable for negligence. So the bailee owes a duty not to be negligent. So you have duty not to use the goods otherwise than according to the terms that you are agreed. So if you are given a car, then you drive the car and you are not told to drive the car, then you are breaching the agreements that both parties had, the agreements that you entered into. So you must use the goods for the purpose which you are told. You must keep them. You must take reasonable care. You must take reasonable care of the goods. So the duty. So you must another duty of the bailee. You must return the goods after the bailment period. So duties of the bailer has the duty to disclose any defects as known to him. So if you are going to take the goods, you are going to repossess the goods. If the laptop, go and check where that laptop, check whether there are some defects. Check that goods where there's some defects. If there are some defects, then take the reasonable action. So they demystify the bailee any cause or loss. So you have the duty to demystify the bailee of any loss or cost incurred and allow the bailee to retain lien over the goods not paid for, whether bailee has done worse. So you must allow him to retain the lien if you are not paid for the goods that you are given him. I think, guys, you have understood bailment, or what bailment is, and you have understood that it involves the bailor and the bailee. So the bailor is someone who has that ownership title, and the bailee is that person who has that temporary title, who possesses these goods for the bailor. So they may enter into a contract or condition, whether implied or statutory, and these goods must be returned to the bailor after the purpose, the use which it was intended has elapsed. So we have looked at the types of bailment. We have also looked at the nature of bailment, what the case classicals of Cox versus Barnard. We also looked at what Denning says about bailment, that bailment is independent, is not about what the contract say or what the common law came up, or what the view of common law is so independent of common law, and it does not take into consideration the terms of the contract. We also looked at various case laws on the bailment, and I think with that you have understood a lot on bailment. We also looked at the creation of bailment, on how bailment is created, and I think that is the end of my episode, and have a nice day.